Court is calling 2025 CR 006636, State versus Michael Lee Gabbert. Can I have parties announced?
Duffy Pitluck for the state of Texas, Your Honor.
Michael Collins, attorney for defendant, present and ready, Your Honor.
All right, are there any applications?
No, Your Honor.
All right, counsel, you received all discovery.
I have, Your Honor.
Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Are you Michael Lee Gabbert? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Gabbert, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, Your
Mr. Gabbard, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
All right, and you understand you have a right to jury trial?
Yes.
A right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent?
Repeat.
A right for you or your attorney to cross-examine any witnesses the state would call in the right to remain silent?
Yes.
Are you giving up those rights and entering into a plea? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 118 days in the Bexar County Jail under 1244. There are no applications. The state will take in consideration 2025 CC 001024, and there's to be $60 restitution to Bexar County Crime Lab for testing. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Honor. It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
I've reviewed it with my client, Your Honor. We haven't checked.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, please.
Anything you wish to say on behalf of your client?
He's done a lot of time and he's accepting responsibilities for that. Your Honor.
All right, the court, as previously stated, is finding you guilty. The court will sentence you to 118 days in the Bexar County Jail under 1244. Give you credit for any time served. Take in consideration 2025 CC 001024, and there should be $60 restitution to Bexar County Crime Lab for testing. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. If you don't get control of this drug habit, only two things are going to happen to you. Either you're going to end up at the Bear County Jail, or either you're going to end up where somebody has to identify your body. You understand?
I agree.
All right. And have you had that looked at on your face?
Yes. It takes a specialist, so it popped one time in Bear County, and they just said leave it alone. So I'm gonna take care of it as soon as I get out. It's been there for almost 10 years. I was in a car wreck.
All right. So you better have someone look at that. Okay.
Thank you.
All right. Good luck to you.
Thank you.
Okay.
Yeah,
Next
but-
issue.
Yes. All right. Defense has filed a motion to set bond. Have you had a chance to review this, State?
I have, Your Honor.
All right, State, are you ready to proceed?
Yes, Your Honor.
Is there an agreement or no?
There's agreement as to the amount, Your Honor, and we'll address anything else the court would like us to, but it's 40,000.
All right. What is his criminal history, please?
He has this charge pending, Your Honor, for assault, family choking. He also has possession of controlled substance. More than 1 gram, less than 4 grams pending. He has the new charge that he picked up for violation of protective order and criminal mischief.
All right, so we can go off the record. This is what I'm tell both parties. If he has an assault, family choking, breath, impeding breath circulation, and then he picks up a violation of protective order, is it alleged to be the same complainant?
Yeah.
I'm not inclined to set a bond in this case.
May I address it, Your Honor? I'm
yeah.
sorry, with all due respect, Your Honor, just
Yeah.
whenever the time is appropriate.
No. I understand. So this is what I'm going to tell parties. The court is not inclined to set a bond on this. We can set it for another hearing. State will either have their witness present or they won't have their witness present. And also what I can tell you, Mr. Gutierrez, legally, if you look at the new laws and the new laws that have since been enacted and the new statutes, these cases are not one where I, as a judge, can just say, oh, well, I'll go along with everybody's agreement, especially if there is a violation of protective order that comes afterwards. So before I even feel comfortable with setting a bond for you, there's going to have to be witnesses. Again, if no witnesses are called, I will tell you legally, remanding without bond is not allowed. Well, it is allowed in a sense, and then not allowed in a certain sense. So once somebody's bond has been remanded, then witnesses need to be called in, because otherwise a bond will need to be set. So I'm going to give both parties a chance to bring witnesses if they so choose. I'm not allowed to go out and subpoena people. So if the state doesn't subpoena a witness, they don't subpoena a witness. If that witness doesn't come, that witness doesn't come. And then in that situation, I would feel more comfortable as far as strongly considering going along with your plea bargain agreement as far as your plea, as far as a setting of a bond. Because right now, with the state requesting 40,000, and there is a alleged, I don't take anything as true until I heard evidence, an alleged violation of a protective order against the same complainant, that's concerning for the court. So if y'all would speak with Ms. Ferguson
Yes, ma'am.
and get a setting, and we'll take it up.
Very well, Judge.
All
Will
right,
do.
thank you.
Yes, ma'am.
All right, let's talk about that. This hearing had the familiar structure of a plea deal proceeding, but it also offered a brief glimpse into some heavier concerns that the court had to grapple with. Judge Boyd maintained a composed and measured presence throughout, fair but firm, especially in the closing moments when addressing broader safety concerns and the legal implications of bond decisions. The defendant, Michael Lee Gabbert, appeared cooperative and composed, answering clearly and respectfully to every question posed by the court. He entered a plea of no contest to a state jail felony for possession of a controlled substance under 1 gram and was sentenced to 118 days in jail with credit for time served. Judge Boyd was meticulous in ensuring Gabbert understood every right he was waiving from jury trial to cross-examination underscoring a courtroom process that, while routine on the surface, was carried out with careful attention to procedural integrity. Defense counsel Michael Collins appeared well prepared, offering brief remarks about Gabbard's time already served and his acceptance of responsibility, while the state presented its exhibits without objection. Things took a turn, however, when the discussion shifted to a subsequent motion to set a fine. It became clear that Gabbard has other charges pending, specifically a violation of a protective order, criminal mischief, and a serious family-related choking allegation. At that point, Judge Boyd made it clear she was not inclined to set a bond without witness testimony, pointing to recent legal changes and the gravity of allegations involving the same complainant. She remained legally grounded, noting the fine. Line courts must walk in bond decisions involving repeat violations, and she emphasized that without live witnesses at the next hearing, the court would have to reconsider its options. Even in that moment, she was transparent and respectful to both sides, offering clarity on how due process will continue. One small personal exchange did add a human moment, Judge Boyd asking Gabbard about a facial injury from a car wreck, gently urging him to see a specialist after release. It was a reminder that while the courtroom must deal with the legal facts, the people involved are still individuals navigating their own paths. All in all, this was a by-the-book plea hearing with a thoughtful and serious detour into bond setting, territory that demonstrated how courts must balance public safety, legal precedent, and procedural fairness. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,